So, hello everybody. So this is the last 3CL seminar of term. We have Professor Jens Henrik-Binder, who's been Professor of Private Law, Commercial and Corporate at, I'm not going to do the whole university, the university in Tübingen. I shall pronounce it wrongly. So he graduated in Freiburg. He has done an LLM at the LSE, and he's actually visiting the LSE at the moment, which is why we're very lucky that he's been able to come here. And he works in the area of banking and securities regulation, corporate and insolvency law. And he's going to talk to us today about CSR, ESG and directors' duties. Thank you very much.
Right, thank you very much, Louise, for this kind introduction, and thank you for having me in the first place. It's a great honor and a pleasure indeed to have been invited to Cambridge. I understand it's the last week of the term, so I'm disturbing you in a way. I'm standing between you and term holidays, which I'm sorry about. But anyway, thanks for coming. And the topic today is about a paper that I have been writing over the past year or so. It deals with a rather controversial and at the same time highly topical question, namely the relationship between initiatives that we've seen over close to a decade now to enhance firms' awareness and firms' activities supporting stakeholder concerns. On the one hand, this is a trend that, as you will probably know, has been going on in a multitude of jurisdictions worldwide. I'm examining the implications this may have, on the other hand, on directors' duties in firms. So the structure of the paper that I'm presenting here is rather complex, as is the topic. I think there are two elements that are worth considering. First is a theoretical analysis, and that has to do with the fact that according to a large body of academic literature, corporate laws, corporate governance regimes can generally be said to fall within one of two categories. One called stakeholderist and the other one called shareholderist or shareholder-oriented, and this has to do with the question what purpose, what objective corporate directors should apply when forming corporate decisions. So the first bit of the paper is about how this new debate, how this new trend that can be observed on both sides of the Atlantic has to be interpreted in view of these traditional concepts of corporate law doctrine. The next element then focuses on what we see in the European Union, where, as I shall explain later, the development has taken very much a regulatory approach, where the European Union legislator has come up with a number of legal initiatives and indeed already complete legislation promoting further attention to stakeholder concerns when forming corporate decisions. So I'm looking at that development and see how this fits into the broader picture. And finally, in the second to last heading here, I'm looking at what the outcome actually can be expected to look like. So how are corporate directors, in view of these new demands and in view of new legislation that has come up during the past couple of years, can be expected to respond? How is this going to change real behavior in terms of corporate decisions? So that's the paper. I think to put things in perspective, it is useful to look first a little bit at what is going on. What we see is a global trend, as I've said before, a global trend promoting the incentivization, as I would call it, of corporations to integrate environmental and social concerns. And there the problems already start. We're talking about a wide range of potentially conflicting objectives. And we're talking about a trend that is visible as such, but is very incoherent. So it takes all sorts of different forms, depending also on the jurisdiction we're talking about. And again, this is something I'll return to in a moment. The question then is, how does this trend impact on the existing legal doctrines in terms of corporate governance paradigms, as I would call it? So how does this trend fare with regard to those jurisdictions that can be called stakeholder-oriented already, traditionally, and how does it have to be evaluated in jurisdictions that focus on the shareholder as the ultimate beneficiaries of the company? Then the next question would be, if we have difficulties describing the trend, if we have difficulties to determine what the trend is actually about, right? Is this actually to be perceived as a regulatory trend, a regulatory phenomenon with the state intervening and requiring corporations to adopt certain policies to refrain from other activities that may be perceived harmful for stakeholder interests, or what is it actually? And here the initial intuitive, if you want, impression that you see or you get at when you look at the global trend is that it's not quite easy to actually determine whether we're talking here about a regulatory phenomenon or, on the other hand, about something that can be characterized as state regulation. Why? Well, we do see, certainly, a large amount of activities out there in the market which indicate that a lot of the recent trend towards greater stakeholder awareness, as I would call it, is actually market-driven. Right? We see a vast amount of ESG ratings coming up, which indicates that there's investor demand out there for rating agencies to help them ascertain how a particular firm's attitude towards stakeholder interests actually is. We also see very prominently the 2019 Business Roundtable statement, a statement issued by the CEOs of large US firms, arguing that the purpose of the corporation, its fundamental role in society, should be reinterpreted so as to emphasize the role of firms for the attainment of interests other than their shareholders' interest in long-term profitability. So we do actually see a lot of evidence that this could be interpreted as a market-driven rather than a purely regulatory development and a trend, and I'm going to discuss this further as I proceed. At the same time, very importantly, and this is also going back to some of the functional issues to be discussed and to be analyzed in this context, what we also see is that the empirical basis that we have as far as the investors' or customers' preferences are concerned is actually very weak. So not only is there a weak empirical basis as far as the the trade-off between stakeholder awareness and firms' profitability is concerned, we also are not quite sure, if we look at the economic literature, what investors, what customers in the 21st century actually expect. So this again casts some doubt about the interpretation of this trend as a market-driven trend. So there's a lot of things that are simply unclear if we start from the empirical basis. So what are the fundamental questions I'd like to ask against this broader backdrop? The first question, really, as I indicated before, is what the implications of this trend, however we can conceive it, might be on the existing doctrinal concepts of directors' duties. Is there a difference in terms of the assessment of what we see as a trend between those jurisdictions where stakeholder orientation is already permitted and those which adhere to the concept of stricter shareholder supremacy, or is there not? And if so, what is the difference like? What are the consequences of it? Again, the question then becomes, irrespective of the doctrinal background perhaps, how can directors be expected to actually respond in their day-to-day administration of the firm to these trends? In this regard, it is important to note from the start that so far, on both sides of the Atlantic, what the actual expectations are and what the actual duties are is actually very unclear. So there's a great deal of legal uncertainty out there. And one of the questions that I want to address in my paper is whether we should regard this legal uncertainty as restrictive, so as fending off directors to take decisions they could otherwise take if the uncertainty didn't exist and if it was clearer what would be expected from them, or if alternatively this uncertainty could actually be used in a sort of constructive way, giving them more discretion as to the orientation of their decisions. And then the last question is really, what are directors, or can directors be expected to do in order to deal with this situation in a broader sense? So can they try and shape the standardization of best practice, for example, including by way of participation in self-regulatory initiatives, in order, first of all, to gain some more solid ground for their day-to-day decisions? And if that is so, what would be the impact of their position vis-à-vis the companies they are supposed to lead? Now, those are the questions. And let's start by looking at the backdrop in traditional corporate law doctrine in a little more detail. Right? It is certainly the case that jurisdictions so far differ in terms of the role of stakeholder interests in corporate decisions. Some jurisdictions take a rather restrictive perspective, others take a more permissive look, but still the trend that I talked about is a new trend in that it focuses more and more on the recognition of positive obligations. So rather than just talking about the limits of directors' discretion, this trend focuses very much on what we actually expect directors to do in order to support and further stakeholder interests. And this is what has led to prominent US academics to talk of a new stakeholderism, which ranges from the recognition of specific positive obligations for corporate directors in this regard, through to a complete redefinition of what is the corporate purposes, so the fundamental role, again, of corporations in society. And what is particularly new in this context is the fact that this would involve also the recognition of positive positive duties of corporate directors to promote stakeholder interests in whatever form. And we will look at the European example later, which demonstrates quite vividly how drastic those consequences could be. So first step would be to examine then the relationship between this new stakeholderism and the established concepts of corporate law doctrines on both sides of the Atlantic. And here we do find in a number of US jurisdictions a rather clear-cut focus on shareholder primacies, shareholder supremacy, it's called in different terms. That is the idea that there is only one purpose and one legitimate objective to be pursued in corporate decision-making, and that is the long-term profitability of the firm. So the idea that corporations are there to enhance the shareholders' benefit, right? And all measures taken by corporate directors, all decisions taken by them, all strategies adopted should be measured against that objective. Now, when you look closely at the emergence of that doctrine in US law, you see that, yes, we do find the strict formulation of the principle, but usually what we also see is that in the application of the measure to specific corporate decisions, that measure is actually relaxed at the operational level, as I would call it. So you will have heard about the business judgment rule, which is the recognition that in pursuing their activities, corporate directors do have a margin of discretion. And as long as they can demonstrate that what they do is reasonably tied to the interests of the firm as a whole, and thus to the shareholders' interest, then they are fine and they won't be held liable for costs that will have been incurred for that. So when you look at the case law, you see that US courts have interpreted the strict notion in a rather flexible way, which also allows for specific measures, specific decisions taken in the interest of stakeholders, rather than the firm's shareholders as such. When you look at what is called stakeholderist jurisdictions, and Germany would be one of them, you find that there are differences in terms of the actual formulation of the principle, but actually similarities in terms of economic outcomes. inasmuch as German law has always recognized a wide margin of discretion to reconcile the corporate interest, the interest of the firm as such, including its long-term profitability, with stakeholder interests, the protection of stakeholders in the first place. But when it comes to operationalizing this principle, what you see is that courts have been very restrictive at applying the principle in practice, so that at the end of the day, when you compare actual scenarios, actual cases between those jurisdictions that actually allow for the recognition of stakeholder interests as legitimate objectives to be pursued in corporate decisions and more stakeholder-oriented, you see that there are differences, but these differences do not matter that much. So if we take this as the starting point, what then are the differences between those established paradigms of corporate governance in relation to the problem that I'm discussing? Are there any? Yes, there are, as I said, differences in terms of actually applying principles, but at the same time, you see close similarities in terms of economic outcomes. It could be that a system which basically applies the notion of strict shareholder orientation, essentially because of what we call the expressive function of norms, signals to a greater extent that protecting stakeholder interests rather than shareholder interests is less legitimate. But apart from that, the actual outcomes, as I said, we compare the details, are rather similar. However, both systems are similar also in a second respect, which is very crucial when we talk about the impact of the new stakeholderism on existing concepts, in that both regimes do recognize a margin of discretion for the advancement of stakeholder interests, but they do not, as yet, according to established principles, recognize any positive prescriptive obligations for corporate directors in this regard. So corporate directors are permitted to use corporate funds in a certain way with a view to the protection of stakeholders, but they're not required to do so in any respect. They're responsible only for furthering the profitability, the long-term interests of their firm. And they are permitting such activities only to the extent these activities, these measures are consistent with the ultimate financial success, the profitability of the corporation. That applies across the board, irrespective of whether we can qualify the relevant jurisdiction as stakeholderist or shareholderist. So what does that tell us about, first of all, the role that the new stakeholderism plays in the US legal world, where the doctrine of shareholder supremacy reigns, at least perceivably? Why have stakeholder concerns become so prominent in that system, which adheres to strict shareholder supremacy? Well, first of all, it's not as clear as one might think whether we could call the whole US corporate law world as shareholder-oriented. And for those of you interested in that, I invite you to have a look at the new draft restatement, Corporate Governance, issued by the American Law Institute and drafted under the auspices of inter alia Edward Rock, a prominent US corporate lawyer. That draft restatement shows us quite clearly that there is no such way as one single corporate law concept in the US. There are differences, strong differences between the several jurisdictions, but all of them certainly do permit, and this is something that I'm looking at in more detail in the paper, all of them certainly do permit directors to actually respond to actual market-driven investor demand in this regard. So there is no inconsistency here. If US corporate laws across the board, again, do permit taking into account stakeholder interests to a certain extent, and if they are all geared towards allowing a great deal of shareholder participation in the decision-making process by a strong voting regime, it is rather understandable that they offer plenty of ways to activist shareholders, bringing in stakeholder interests in the corporation and actually facilitating a move towards greater stakeholder awareness in this regard. So that's something I explained in more detail in the paper. Then this helps us to understand also what is actually new about this new stakeholderism. The difference really very much boils down to the question whether we just merely recognize power to take into account stakeholder concerns when making decisions at the top level of the company, which is what has been recognized both in stakeholderist and shareholderist jurisdictions, again, or whether we actually impose positive obligations on corporate directors, obligations, for example, to systematically explore the stakeholder implications of their firm's activities, to take specific organizational steps in order to mitigate adverse implications, to reach out to and support individual stakeholder groups, or to refrain from using specific business opportunities if these are found to be detrimental to stakeholder access. If we do recognize, and to the extent that we do recognize such obligations, we certainly deviate, and that's one of the key points of my paper, we certainly deviate from established concepts of corporate governance, irrespective of the broader background as stakeholderist or shareholderist. No jurisdiction so far until recently has recognized obligations to that extent. So that's the core of the theoretical background, and this slide basically goes to explain this a little further, but in the interest of time, I think we can move on to the analysis of the European law framework in this regard, because that provides useful illustration of how far this broader trend can actually go in terms of changing existing directors' duties. So in Europe, the development started as early as 2003 when the European legislator first required public corporations to disclose information on environmental and social aspects of the firm's activities as part of the management report and annual accounts. To the extent this was necessary for an understanding of the company's development, performance, or position. So when you look at that, you very much had something that was totally in line with existing concepts, to the extent that implications of the firm's activities on stakeholders had an impact on the firm's financial performance. This had to be reported. We then had, in 2014, a new directive requiring a much broader, companies to disclose a much broader range of information, and that already went beyond that. And this framework was then amended again in 2022 with a new CSR reporting directive, which first of all drastically expanded the scope of application of the earlier directive and incorporated a much broader notion of ESG aspects. The idea being here, as I describe here at the top of the slide, that corporations should publish information so as to facilitate investors' assessments as to whether or not they consider this investment an investment compatible with their own preferences with regard to social and environmental activities and policies and implications. So the idea was to instigate a market-driven demand by providing investors with information they perceivably needed in order to determine whether the investment as such was actually one that they should incur. And that can be called indirect procedural regulation. This may now change under a new Commission proposal of last year, which imposes or anticipates a wide range of positive obligations. So in addition to merely reporting on their ESG and CSR preferences, firms will, under this new directive, if it becomes adopted, ultimately be required to actually change course if there are any adverse implications of what they do on stakeholder interests, not just in their own jurisdictions, but across the world, essentially. So they will be required to refrain from specific harmful activities. And importantly, that new directive proposal also includes a redefinition of corporate directors' duties of care. And I'm not going into this to a large extent here, just point to the formulation of the new duty, which purports to and aims at expanding the scope of decisions in this respect. So Importantly, and this is nothing I want to discuss in detail, all this goes back to international standards. International standards have been incorporated in several technical ways into European regulation to that purpose. So a lot of the obligations included in European regulation is referring to international standards so that managers in the long run have to declare and have to readjust their own activities by way of reference to a large number of international standards applicable both in the area of social regulation and of environmental regulation, and I just included a list of those standards here. So what can we say about the nature of these standards? As I said before, so far, the focus of European regulation and the key strategy has been procedural. So rather than imposing specific positive duties, we've required corporate directors to actually disclose information, expecting investors to act on the basis of that information. Importantly, those standards are, at first sight at least, principles-based in that they rely on vaguely defined terms. So firms are required to report on and identify the material impact of their activities, adverse human rights implications, whatever that might be, take reasonable measures and so forth. So you find a host of vaguely defined terms rather than specific rules requiring to do this or refraining from doing that. What we also see is that these standards treat a wide range of interests indiscriminately. So without any differentiation between those interests, even though these may conflict. So, for example, if you close down an environmentally harmful plant, you will lay off people. This will cause social implications and so forth, and we don't find any resolution here. So how are directors, in view of this uncertainty, how can we expect them to react? How can they be expected to respond? And this is, of course, key to the understanding of the full impact of this new wave of regulation. If you look at the literature, especially practitioners' literature in whatever jurisdiction you may think of, you will find a lot of complaint about the uncertainty associated with this particular trend, right? At the same time, it is rather unclear whether the restrictions that are complained about actually exist, because the terms are so vague and the sanctions are potentially so weak that it is really questionable whether directors, simply by virtue of those new standards in association with new sanctions, are actually expected to refrain from activities that might be profitable, but that they might be concerned about. A possible alternative interpretation, and this is something I again look at in more detail in the paper, is that, as I said at the beginning, this uncertainty could actually be used in constructive terms, right? Corporate directors could actually try and exploit this wide margin of discretion in order to broaden the discretion yet further, right? Purporting to pursue policies and strategies in the interest of stakeholders, but at the same time simply widening the scope for self-serving activities without any meaningful control according to the traditional restrictions of corporate governance. And this is, I think, very much in line with a prominent critique expressed by Babchak and Talarita, among others, that we're talking here about a wave of new activities, of new demands on public corporations that might actually free up managers to do whatever they think, leading wherever they want. So I then discuss the impact of self-regulation. I'm not going to discuss this in detail here, but let me just point to the fact that some of the standardization that is going on is actually being carried out by self-regulatory initiatives, which have received a lot of contributions from the industry itself, which could indicate that there is indeed a great incentive for corporate directors to pursue this channel in order to draft the applicable standards, which they then will be required to follow, in a way as convenient for them as possible. So What do we find? Let me conclude, first of all, by pointing at the differences between the US and the EU trends in this regard. In both jurisdictions, as I've said, greater stakeholder awareness has been debated very heatedly in recent years. But when we look at the details, we see that there are huge differences. In as much as in the EU, this is broadly a regulatory issue, whereas in the US, there are no regulations yet, so it's basically a phenomenon driven by investors. And one of the points I make in the paper, and don't have the time to go into here, is that directors' responses to a statutory regulatory regime might look very different from directors' responses to actual and specific investor demand. So I summarize the findings here. We do see differences between the two jurisdictions. We see a broader trend. So far in the EU, the trend has been operationalized in what I call an indirect and procedural way. However, and this is important, in the absence of standardized information that would allow for discrimination in investment patterns, so in the absence of actual information that would actually help investors to make their choices work, and secondly, in the absence of unclear empirical evidence as to what investors actually want, the potential for this regulation to accomplish its positive objectives in terms of social and environmental concerns remains dubious. It is unclear if investors do care at all, and it is unclear whether they actually did care. Even if they did care, they could actually distinguish between different strategies and different firms, different investments on the basis of the information that is published. So maybe we shouldn't expect too much from this kind of regulatory strategy. And all in all, it is quite likely, I would argue, that especially the European framework certainly will have an impact on firms' behavior. But whether or not that impact will actually be positive in terms of actual outcomes for stakeholders remains dubious and, in my view, is rather unlikely. And with that, let me close. Thank you for your attention, and I'm happy to answer any questions that you may have.